everybody. To everybody in the room, thank you all for braving the remnants of Snowzilla to join us today, and for everyone who's on the remote feed. We're glad that you can still participate, and we hope to be a timely and interesting discussion. My name is Kelly DeMarchis, and I'm counsel in the Privacy and Data Security Group at the Venable law firm here in Washington, D.C. I'm delighted to be moderating this afternoon's panel titled The Collapse of the EU Safe Harbor. Our topic is one that certainly has been heavily discussed even in the sessions this morning. Since the October 6th ECJ validating the U.S. EU Safe Harbor, the thousands of U.S. companies who have relied on the program to engage in lawful transfers of personal information from Europe to the United States have been thrown into some degree of uncertainty. I'd hoped we would be discussing Safe Harbor 2.0. With regulators on both sides of the Atlantic still saying there is a chance it will come before the end of this month. Even Commissioner McSweeney's remarks this morning, she called herself an optimist about a Safe Harbor 2.0 coming next week. But to get an update to start on where the process is, we're delighted that we were joined by Justin Antonipallai, who, as of today, has the title Counselor to the Secretary with the delegated duties of Undersecretary of Economic Affairs at the Department of Commerce, who, of course, has been the lead regulator in the negotiations with the Europeans on the new Safe Harbor. He is catching a plane, so we're going to play with the format a little bit. He's going to make some initial remarks and then jet out of here in his helicopter to Dulles or however he's getting to Europe. And then we'll introduce the rest of the panel and proceed with the session. So.
Oh, gosh. Share with you.
Absolutely.
So, Kelly, thanks very much, and thanks to the State of the Net Conference for having me here today. I'm only going to be able to speak for a few minutes. The weather has managed to make my presentation here even shorter than it was going to be so that I can catch a flight. But I did want to spend a few minutes talking about where we are in the Safe Harbor discussions and giving a few minutes of background before our terrific panel that Kelly is leading, including Andrea Glorioso from the European Commission, who we've worked with for many years at this point. As Kelly mentioned, myself and my colleague from the International Trade Administration have been leading a broad interagency group that includes DOJ and the intelligence community and other elements of our government in a discussion with the European Commission for more than 2 years now. So we have had a very productive set of communications and negotiations around improving the Safe Harbor framework and also providing more information about the limitations and the safeguards under which our intelligence community and our national security elements operate. And for many reasons, we have a very strong case to make on both of those elements because our intelligence community and our national security and our law enforcement elements operate under very well-known limitations and safeguards. And so part of this has been a long dialogue to make sure that we are level set and that we've been able to provide information to the European Commission about the way our intelligence community and national security elements do business. Obviously, we then had the Schrems case following several years of discussions that came out at the beginning of October. One thing about the case that I think is worth focusing on before I talk about how much we have been focused to make sure that any new Safe Harbor satisfies that case is it's important to focus on what exactly the Schrems decision did. The Schrems court, the ECJ, in the case actually was quite focused on what the Commission said in its decision in 2000. And most of its focus in the ECJ's discussion is about flaws in the Commission's decision and how those might be fixed in the next adequacy decision. And why is that important? It's important because two of the main holdings of the Schrems case were that limiting DPA jurisdiction or authority in Europe carries with it legal risk if you do it again. And second, that any time the Commission enters another safe harbor adequacy decision, it should look not only at the framework with sort of blinders on, but should look at the framework together with U.S. law and international commitments and how they work together to provide limitations on the way the intelligence community and national security operate, so that it's a comprehensive look at the way U.S. law operates together with safe harbor. What was not in the decision, and this is important, is there's no findings in the ECJ case about U.S. National security law. There's no findings in the case about the way U.S. Law enforcement works. There's nothing in the case criticizing U.S. companies for the way they've actually followed the principles. And it's therefore really important that what we are focused on is providing a strong basis for the Commission to make exactly the findings that the ECJ was focused on in the Schrems case. And that's essentially what we've been doing for 2 years. In terms of process, I thought I'd just focus on two pieces. One, we've had a very productive dialogue with our colleagues in the Commission for some time. And we've presented and had dialogue over various versions of offers, but including, just a few weeks ago, a new comprehensive offer that we think is one of our best offers on the subject. We're also getting to the point where it's really come to be the time to act. We have data protection authorities in Europe who have talked about next steps beginning at the end of January. And we've presented a very strong proposal that reacts to a lot of the issues in the ECJ case and provides a very strong foundation for the Commission to make exactly the findings, as I say, they're caused to make. But as I said, time is not on our side. It's important that we come to an agreement and that the parties continue to work together. And we're, of course, committed to do what we can within limits to get to an agreement. I thought I would just take one more minute because there's an interesting timing issue that's come up that I'm sure, so folks in this room I sort of take as PhDs on the subject. This isn't an introductory 101 course, so you're probably focused on the fact that the Article 29 Working Party announced a January 31st sort of kickoff for possible enforcement actions. That's on a Sunday. And, we also know now that the Working Party is going to be meeting on February 2nd and that there's going to be communications and dialogue within the Commission and among the college taking place on February 2nd. So although we can't give guarantees about these things, especially because the Working Party is represented by independent DPAs, our expectation based on those timings is that it's really February 2nd, not January 31st, that will be a consequential date at this point. I have, I think, time only for a question or two before I go, but if there's something I can focus on in terms of the current state of discussions, I'd be happy to talk about it.
One of the things that we've tried to get a better understanding of is exactly what's in the latest proposal that the U.S. put forward to Europeans. Folks from the Obama administration have talked at length about how this is the best offer and that it meets the requirements of the Schrems case, but there hasn't actually been much said about the substance of it and on issues like FTC enforcement and transparency. So to the extent that you can offer some of those broad details, it would be appreciated.
Sure, and this is one of those things where we always want to be careful about getting into the details in the middle of these kinds of discussions. I will tell you a couple things. One, obviously the FTC has been quite active in the area of privacy. They're a world-class organization, and our agreement has to recognize the role they play and to respect it. So on both sides, we have enormous respect for the European principles. The United States takes privacy very, very seriously, and we have institutions that take privacy very seriously. And we're focused on various methods that recognize both sides' institutions and procedures. I will focus on, in one way to answer, is that we have spent a lot of time ensuring that EU citizens, with respect to the safe harbor, have many means to actually pursue legal remedies if there is an issue in the future. I will tell you that on the issue of EU citizens having their rights or they're under the principles somehow not respected by U.S. companies, there's really no history of this. In other words, under Safe Harbor as it's been operating for 15 years, there were very few referrals, very few, less, basically a handful to the FTC where there were alleged violations. So the actual history of it is a very strong company compliance, and there was nothing in the ECJ case that actually focused on that problem. But we are focused on that problem. We have wanted to make sure that EU citizens, with their data, have multiple avenues to pursue legal remedies, including cost-free alternative dispute resolution, using the Department of Commerce to help them resolve issues. And obviously, for those of you that have studied the ECJ case as well, one of the things that was interesting about it is that while it identified issues that needed to be covered in the next adequacy finding, it also made clear that DPAs were now going to be empowered in Europe to actually investigate the safe harbor issues. So in some ways, the ECJ case itself provided a very strong method for EU citizens to bring to their own DPAs in Europe complaints so that their DPAs in Europe could follow up on them on that side of the Atlantic. We obviously have to respect our enforcement mechanisms, including the FTC, and we want to be careful about situations that you would subject companies to all of the 44 DPAs in Europe in addition to the FTC. So we have to be thoughtful about these things, but we are very, very focused on making sure that the safe harbor is improved, that we respect both sides' institutions and laws, that we provide enough information about the way our law enforcement and national security apparatuses operate and all of the limitations and strictures under which they do operate, which, as we know, the ECJ case sets up a standard of essential equivalence. It doesn't set up a standard of identity, right, or absolute of the same, right, on that issue. That's probably the worst phraseology I've ever used, but forgive me, it's been a lot of snow over the last couple of days. But we're focused on these issues, and we're trying to set up a durable, strong framework, and one that the EC can really make a new finding on. And with that, I apologize that I have to leave, but thank you very much, and hope this was helpful.
Thank you, Justin.
Okay.
Off to go negotiate the final deal, let's hope. Okay, so now let me introduce the panelists for this afternoon's discussion. To my left is Mr. Andrea Glorioso. He's counselor for the digital economy at the Delegation of the European Union to the United States in Washington, D.C. In this role, he acts as the liaison between the EU and U.S. on policy, regulation, and research activities related to the Internet and information and communication technologies. Mr. Glorioso also worked for 8 years at the European Commission in Brussels on cybersecurity, personal data protection, cloud computing, and Internet governance. And then to his left is Bijan Madhani, Public Policy and Regulatory Counsel at the Computer and Communications Industry Association, where he concentrates primarily on privacy and surveillance policy, cybersecurity, and internet governance issues. And then also appearing via Skype is Professor Meg Lita Jones, Assistant Professor at Georgetown's Communication, Culture, and Technology Department, where she researches and teaches in the area of technology law and policy. Her research interests cover a wide range of technology policy issues, including comparative privacy law and the governance of emerging technologies. So we've heard now from the U.S. perspective, but we thought we would open up this afternoon's panel by getting the European rebuttal. So Andrea, what's your response to Justin? And he's gone, so feel free to take him on directly.
I'm sure right now Justin is following or streaming, so I have to be careful. Anyway, what I'm going to say, thank you, Kelly, and thanks to all of you for being here. And by the way, I think it's really incumbent on me to thank the organizers for managing to rearrange this conference in very difficult conditions. So thanks to team and to all the team at State of the Net. I really don't think that what I want to do is a rebuttal, because by and large, I think that both based on what Justin said and in general the negotiation that we've been having with the US government, we're actually on the same page, quite frankly. And the European Commission has made it very clear on the, I think that immediately on the day of the ruling of the European Court of Justice, which was indeed on October the 6th, which is a day that I will remember for a long time, as it has been the start for 2 or 3 or 4 very difficult months, very complex months here at the delegation in the US. The European Commission on that day issued a press release, gave a press conference, and we made it very clear from day one that our objective was to safeguard the flow of personal data between Europe and the US and vice versa, while at the same time, and this has to be very clear, ensuring that the respect of European citizens, ensuring the respect of European citizens' rights, given the new framework or the clearer framework that the court has handed us. Allow me, even though I understand that perhaps a lot of people in this room are very much aware of that, but I think it's nonetheless useful to remind that the Court of Justice of the European Union, or European Court of Justice, is our top court, is the equivalent, mutatis mutandis, it's a different legal system, but it is the equivalent in practice of the US Supreme Court. So I want people to be very aware that this, as far as we are concerned, is the law of the land. We have no neither possibility nor, quite frankly, desire to bypass what the court has told us. Another thing that I will say, which I think is very important to understand where we stand with the negotiations and what we want to achieve, is that if you take a step back, what we have been discussing with the US since October the 6th is, in fact, that discussion is a discussion that started way before October the 6th. Because already in October 2013, so more than 2 years ago by now, the Commission, following the fact, I think we can be very honest about that, following the so-called Snowden revelations and the very deep political impact that those revelations or leaks or whatever you want to call them had on the European public, the European Commission, rather than suspending at that point in time the safe harbor arrangement, which many parties in Europe, many people in Europe wanted us to do, we said, well, no, we think that the safe harbor, the 2000 safe harbor decision has to be improved, has to be strengthened, and we came up with a set of 13 recommendations, which are publicly available. And we have been conducting discussion with the US government since October 2013 on the basis of those 13 recommendations. And I think it's, even though it is true, what Justin said is true, that if you actually look at the ruling of the European Court of Justice, most of what the European Court of Justice says is about the European Commission. It's about the Irish Data Protection Authority, it's about the EU legal order, and it's about the 2000 safe harbor decision. Now, as a Commission official, I don't have the habit to comment or criticize on the decision of the European Court of Justice. I will say, though, that another point it's important to remember, we are talking about the 2000 safe harbor decision. It's been 15 years. So in a way, I think it's quite understandable that there were and there are elements of the decision which needed improvement, and this is what we've been doing with the US. And part of the remarks, part of the reasons why the European Court of Justice struck down, declared null and void the 2000 safe harbor decision, were in fact issues that the European Commission had already identified in those 13 recommendations. And part of those have already de facto been solved, or there is an agreement already with the US government. In terms of where we stand with the negotiations, I'm afraid that I can't really get into the details for reasons that you can easily imagine, but also because, quite honestly, these negotiations are literally right now, they're literally happening every single day. There are phone calls or video conferences, or in some case face-to-face meetings, which is one of those meetings I think Justin is going to every single day. So whatever I tell you today might change tomorrow. Don't think there is a lot of sense in making that. But the broad contour of what we have been discussing with the US government are known. It's about having a proper redress for European citizens in the US. And although we fully, and I want to be very clear on that, we have great respect for the US system, the fact that up to now there hasn't been adequacy finding says nothing about the fact that we recognize that the US system within the confines of the US as a nation works well. And we have deep respect for the enforcement powers and enforcement activities of the Federal Trade Commission. On the other hand, much like data protection authorities, the FTC is an independent authority. So for us, the question has been, since the US government cannot bind the FTC to follow up on any particular complaint by European citizens, in the same way in which, by the way, the European Commission cannot bind the data protection authorities to follow up on complaints, because they are all independent authorities. So the question for us is, can we make sure that in those cases, which might be limited, but as the court pointed out, this is a point of principle. It's a fundamental right of European citizens to have appropriate judicial redress. I think it's Article 47, if I remember correctly, of our Charter of Fundamental Rights. We've been discussing with the US, can we make sure that in those limited cases in which there is no possibility for FTC enforcement, the European citizens can have, or intervention by the Department of Commerce or alternative dispute resolution systems, that European citizens are anyway covered. This is one of the things we've been discussing with the US government. We've also been discussing, and the Department of Commerce leading the interagency group on behalf of the US government, we've also been discussing, can we have as much clarity as possible on the actual safeguards and limitations on access to personal data of European citizens transferred under the safe harbor regime, access by law enforcement authorities and intelligence agencies. I think that is also important because, we take at face value what the US tells us. The US is our main ally. We are together in NATO, and we've been together, and we are together on many security issues and rather complex issues across the world. But still, I think it's fair to say that, from my perspective at least, or from our perspective, the precise framework under which at the federal and state level law enforcement agencies and intelligence agencies can access data is not always clear. And part of this is also because we recognize, and this is a very positive development, that in the past 2 or 3 years that there have also been developments in the US, legislative changes, new frameworks, executive action, and so on and so forth. So there, we've been asking for more clarity, if at all possible, on what is the actual framework. I think I will move towards conclusion and hear from industry why we are screwing up everything and why we should all get all back home. And we heard a lot of that lately. I want to make one point very clear, that throughout our discussion with the US government in the context of the safe harbor discussions, we have not asked for legislative changes in the US. We have not done that. Our objective is to arrive at a situation which is satisfactory on both sides, but quite frankly is satisfactory from our perspective. It respects the ruling of the European Court of Justice. It abides to the 13 recommendations that we have put forward in 2013. Of course, it's a sovereign decision of the US government whether they want to propose legislative changes, but that has not been the basis for our discussion so far, because, call us naive, but we think that there is the flexibility to achieve what we want to achieve within the framework, within the legal framework that we currently have in the US. And I think I will shut up now. I don't know if there are questions already at this point in time, but I hope we can make this interactive, and I'll try to say as much as I can about where we stand with the negotiations.
So I haven't got a prepared statement.
Oh, this was not prepared now. It's just ad lib.
So obviously the Commission and Department of Commerce are at the top of their games. So we don't actually have much in the way of complaints about the negotiation, about the way things have been handled over the last 3 months, or even 2 years and 3 months. We've in our interactions with the Department of Commerce, with the Commission, industry feels like we are getting a lot of information. There's optimism in the most recent round of negotiations. So my perspective is sort of one of, just like yours, outside looking in, but we also have the consequence of being industry, sort of being affected by this in the weeds discussion of what's going on in the negotiations. So the discussion of what authority DPAs have in Europe, whether there is a sort of referential authority between the DPAs and the Commission here, whether there's transparency reporting by companies pursuant to whatever is going on in negotiations right now. That all sort of, in the end, comes down to sort of activity that companies have to prepare for in Europe, over here, that can be costly, that can be burdensome for large and small companies. And so we're sort of waiting with bated breath. Uncertainty is the best way to sort of characterize where my companies currently sit. Over the last 3 months, they've been sitting on a knife's edge because they operated in good faith under the prior safe harbor agreement that was in existence for 15 years. So those 15 years of sort of good practice with generally little grounds for enforcement authority from the Commission, as the Department of Commerce and Commissioner McSweeney have mentioned before, sort of indicate to us that our companies were operating in good faith. And so over the last 3 months, without a legal basis, or with sort of a tenuous legal basis at best, the sort of January 31st deadline has loomed pretty ominously. We're actually fairly optimistic based on what we're hearing with our partners in commerce who have been, and our office that is also sort of paying attention from Brussels and in Davos over the last couple of weeks, that the negotiations are going well. The same sorts of points, technical points about the DPA authority, about the sort of sharing of information about the surveillance structure in the United States with the EC and stakeholders there, we hear about just as frequently as you do, and I think things are going fairly positively.
I think even though negotiations agreed, the news is coming out as very positive. Is there any concern that this is essentially the start of a very long and arduous path? I mean, Safe Harbor 2.0 is going to be subject to challenge in the courts. Perhaps binding corporate rules and model clauses also will be opened up. I mean, is there worry that this starts a period of uncertainty that could go on for a decade?
Yeah, I think our companies have been preparing for that since October 2013, since the Snowden revelations. There is sort of a differential, I think, between smaller and larger companies. Larger companies, to the extent they can afford counsel, like Venable. Smaller companies, less so. There is, I have conversations with member companies that are like, well, we were Safe Harbor certified, we aren't anymore, but they'll find some mechanism for us to get along with. And there are some general counsels who are out there like under the impression that MCCs are going to be just fine for the next 2 years without any challenge. I'm not outside counsel, but I do my best to advise them to go find someone who can disabuse them of that notion. So yeah, there is going to be a period of uncertainty, but I also think that there is some reason for optimism, at least in the next couple of weeks when it comes to the conclusion of the negotiations. So I guess narrow optimism, wider concern.
Can I react?
Sure.
If I may, sorry, Mag, to keep you out of the microphone, but on this point on uncertainty or certainty, I think it's important that we all try to see this in a pragmatic but realistic way. So first of all, not everybody might be aware of the fact that even when we get, and I don't want to scare anybody, but again, I think it's important we all understand the procedure here. When we will get, and I say when, not if, when we will get to an agreement with the US, fairly soon, hopefully, in any case, the Commission, the European Commission, which I represent here, will need to make a proposal. That proposal, internal proposal, that proposal will have to be approved or not rejected by a qualified majority of member states. We will have to ask for the non-binding opinion of the Article 29 Working Party, for the non-binding opinion of the European Data Protection Supervisor, and for the non-binding opinion of the European Parliament. Now, anybody who has been working on politics will be very much aware that we are not going, on top of that, we are very much aware because some civil liberties NGOs have been so kind as to tell us very clearly that they're already preparing for a new challenge to whatever will come out of these negotiations, which is fully within their rights, to be absolutely clear. But the bottom line is that both from a political and legal point of view, from our side, we certainly want to make sure that we have a framework that is very, very solid and that we resist any kind of challenge, or as much as possible, any kind of challenge. That's the first thing that people have to be aware of. I don't think it's in anybody's interest that we rush these discussions and then we come up with something that is going to be struck down in 3, 4, 5, or 6 months. I don't think it's good for anybody, not for business, not for us, not for the US government, not for anyone. The other thing that I will mention in terms of the other forms, because again in the discussion, the other ways, the other means to transfer personal data from Europe, from the European Union to third countries, and the US in this specific case, that, yes, as has been mentioned, there are other forms of doing that, there are other ways of doing that, whether it's through model control clauses, binding corporate rules, the consent of the data subject, the performance of the contract. All of this tools to transfer personal data are maintained, and it is the official position of the European Commission, which we express in a communication, so in official policy positions of November 2015, and I'm happy to give you details, because in that communication, the European Commission clearly states we believe that these alternative forms of transferring personal data remain valid. I get it that some people disagree with that. It's within their right to disagree, but that is the position of the European Commission. And last but not least, I think what we're seeing now, trying to look at the broader picture, in life, as any lawyer will tell you, economists and lawyers and political scientists like me will answer to any question, it depends. You have no certainty in life, and anything can be challenged in court. What I think we're seeing now is that there is a lot more attention, both from a political and from an economic and from a cultural and societal point of view, to issues such as privacy and personal data protection, which until very recently, basically nobody cared about. Let's be very clear about that. I've been working on privacy for 15 years at least, and it's fascinating to me to see how much this has become important in the past 2 or 3 years. That was not the case. It was a very restricted circle of very few people who actually were interested. So I don't find it surprising that now there is a lot more pressure on companies and on lawyers and on courts to decide on matters, because this has become a matter of much broader, whether we like it or not, it has become a matter of much broader political and cultural and societal significance. So people who hope that simply because the EU and the US agree on this new safe harbor, then there won't ever be any other challenges, are mistaken. And people better get prepared for that, because, as I said, whether we like it or not, this has become very, very important. And I hope I'm not, putting anyone's mood down, but this is the reality in which we have to work on. And it's important we manage the expectations of everybody properly, especially in the long term.
Hi, Meg. If you can hear us, do you have any reaction to what's been said so far?
Oh yeah, that's a great question, just to react to things. I first want to apologize for not being able to get all the way down to the museum. I'm in the waddle stage of pregnancy, but I see that my galaxy picture from Battlestar Galactica is being shown, so at least there's a benefit. Yeah. I actually want to, if it's okay, I'd like to react to something that was really interesting from what Max Trem said earlier. He really emphasized that that he was just one person, and that if someone else wanted to step in or give him $100,000, that he would continue to fight the good fight, and the good fight, he sees the good fight being this stance on surveillance practices around the world, and I think that is a particularly interesting aspect of this conversation. Is that there's just been a few people involved in kind of tumbling safe harbor and a few other things that were the status quo of the internet that we're all functioning around for a long time. And I don't envy the people that are sitting at the table trying to figure out a framework in light of the fact that the big questions are still on the table. No one's figured out what to do with surveillance versus privacy. No one's figured out how we weigh those as the world keeps changing, how we get these numerous cultures to work together to come to some type of functioning framework so that we can send data back and forth. But also, in addition to that, accounting for the individual efforts that exist and that float around and come in through the court cases at various speeds is also, I think, incredibly challenging. The other thing that I thought was interesting that was said was that the U.S. companies have no history of invading anyone's privacy, or EU citizens' privacy. I don't think that European Union citizens feel as though their privacy has been respected. I'm not sure that Americans feel like their privacy has been respected, and that's another big question. But I don't think that it's necessary to frame the issue as, well, we were doing fine for a while, and then we ran into this hurdle. I don't think that many people would agree with that we were sort of scooting along there for a while in an okay fashion. But safe harbor seemed to have a lifespan that was coming to its natural end around this time anyways, and so I think that it's perfect timing. I think 20 years after the directive is the perfect time to revisit this anyways. I don't think that these people at the table have been forced into this. I think that it's nice timing, but they're not going to be able to answer these huge questions. Their goal is to come up with this framework to provide certainty, which is really challenging because the case itself reads as though they have to figure out these huge questions first.
Thanks for that. So Meg raises the point that Europeans and maybe even Americans might not feel that industry is adequately protecting their privacy. At the same time, the remarks from Commissioner McSweeney and Justin as well said, most U.S. companies have operated in good faith and in compliance with the safe harbor principles. So is a revised set of safe harbor principles enough, or is there a fundamental disconnect between what companies say they're doing with personal information and what's actually happening with it?
I mean, to the extent that there is a disconnect between what individual companies are saying with what they're doing with information and what actually happens with it, I think that's a question for the Commission to answer under their Section 5 authority. They have Deceptive Practices Authority, and the
Federal Commission, the Federal
Trade Commission, not the EC, and they fairly regularly choose to enforce that, use that authority on my member companies on a fairly regular basis. So I don't think there's a question about whether there's a commission, an FTC bite. They have the bark, they have the bite, and they choose to use it on a regular basis. So if there is a concern, I think, about that disconnect, I think there should be petitions to the FTC for broader enforcement authority, perhaps from the FTC to Congress, which I think they've sought, and to sort of address that disconnect, I guess, domestically. Internationally, that's another question for governments to address with governments, and I think that's happening a little bit at the negotiating table for the safe harbor.
If I may to react to the point that Meg raised, if I understood it correctly. Right now, not necessarily me. I mean, I am involved in the safe harbor discussion, but I don't always sit at the table of negotiation. I don't work on it 24/7, thanks God. Other colleagues have to do it. But right now, there is obviously a focus on solving the most immediate issue, which is, again, as we all know, the fact that the Court of Justice annulled this particular framework for transferring personal data, and we have been told in uncertain terms by both the US and European industry that that is the immediate concern that needs to be addressed. And that is also what the Commission said we would address, the European Commission said we would address. So that's an immediate concern. But that doesn't mean that we are unaware of the fact that there is a broader discussion, there is a broader issue to be addressed here, which is what people call the balance. I'm not sure I would call it balance between privacy and security. When you say balance, it somehow seems like by necessity you need to have less of one in order to have more of the other, and I'm not convinced that that is necessarily the case. But in any case, there is a broader societal discussion to be had on what we as a society or as societies in Europe and the US we want in terms of activities of our intelligence services, of our law enforcement apparatus, and so on and so forth. That's a conversation which needs to happen. I'm expressing personal views in this moment. That's a conversation that needs to happen. I think that many parties are contributing to that conversation already. Not all of you will know that the Fundamental Rights Agency, which is an independent agency of the European Union, it's based in Vienna, has recently published a report, so it's an official report of that agency, on the intelligence and surveillance practices of the 28 member states. So I want to be clear, it's not like we ignore that there is a discussion, a debate to be had within the European Union as well. Similar debates have been ongoing for some time now in the US through various means, whether by NGOs, by branches of the government, and so on and so forth. But ultimately, this is not an issue that we can solve in the context. We will not find, in my view, a satisfactory solution to this conversation by the 21st of January or the 2nd of February or whatever Monday might be. I don't have my calendar in front of me. So yes, it's a conversation we need to have, but as a bureaucrat, as a Commission official, I try to prioritize the problems that I need to solve. And right now, we have an urgent issue to address. It's not to discount the importance of the other issue, but we can't, and I'm not convinced, by the way, that the European Commission or the Department of Commerce should be the one speaking on behalf of society on this broader issue of the balance on how much surveillance we want to have. I managed to have Meg drop off. That's a very cool avatar, by the way. So I want that as well. Yeah. So, yeah.
Okay. Let's talk a little bit about the Judicial Redress Act. So, Andrea, you said that we have not been asked for legislative changes, we, the United States, and that's not been the basis for the discussion. True. But there has been a lot of attention paid to the Judicial Redress Act, and certainly statements from stakeholders in Europe saying things like it's necessary for Safe Harbor 2.0. After the markup was postponed again last week, again, a statement came out that said, this could push back the whole negotiation. How important is the Judicial Redress Act, and why is it so important to these discussions?
So let me get a bit technical here. The Judicial Redress Act, and we have been very clear on that, is necessary in order for another agreement, the umbrella agreement for exchange of personal data for law enforcement purposes between the European Union and the US and vice versa, to be approved or ratified by the European Parliament, which is a necessity. It's not a necessity for the Safe Harbor because, again, I don't want to become too technical, but Safe Harbor is not an international agreement. It's a unilateral decision by the European Commission approved by the member states. The umbrella agreement for the exchange of personal data for law enforcement purposes is, for all practical purposes, an international agreement. It has to be ratified by our parliament, and our parliament has made it very clear that it will do so only if in the context of that exchange of personal data, again for law enforcement purposes, there is a possibility for judicial redress for European citizens. And this is why, in cooperation with this administration, with Congress, we have expressed the wish that something like the Judicial Redress Act would see the light. Now, is the Judicial Redress Act technically necessary for the conclusion of the Safe Harbor negotiations? I don't believe so. That's not the information I have so far. Would it hurt if we had the Judicial Redress Act in place? No, it certainly wouldn't. Would it send a difficult political signal if on the eve of trying to conclude on Safe Harbor, the Judicial Redress Act were to be postponed again? Well, after some years in European working around European politics, it wouldn't necessarily send the right signal, let's put it this way. But we have never, and I'm not sure I know which statement you refer to, this statement that you mentioned, I don't know which statement you refer to, but as far as I'm aware, during the negotiation, we never subjected the approval of the Judicial Redress Act. We never subjected the conclusion of the Safe Harbor talks to the approval of the Judicial Redress Act. We did in the case with the Umbrella Agreement, which again is a separate agreement for the exchange of personal data for law enforcement purposes.
I think there was a statement to that effect from Parliament, some groups in Parliament at the end of last week when the markup was supposed to.
I can't speak for the European Parliament, so you will have to ask them.
As to the Redress Act, I think we were consistent with the Commission. We think it's, from an industry perspective, we've been supportive of it since prior to the Safe Harbor decision in October. We think that, from a sort of wider atmospheric political basis, it isn't a sort of another act of good faith by our government, by and our industry from supporting that to show that we have trustworthy practices here with respect to Europeans' data. And in this context, it is limited to sort of law enforcement data transfers under the umbrella agreement that Andrea described. But I think it is a sort of a brick in that wall to sort of rebuild the trust across the Atlantic from internet users' perspective, not so much from the political angle.
Mm-hmm. You have a question, Steve? Oh.
Thank you all. Steve Del Bianco with NetChoice. Andrea, you asked about the balance between security and privacy, and the answer is your answer. It depends. It depends on the proximity and recency of the latest terrorist attack, which is rapidly what is emerging on your continent now. So you predicted there might be additional court challenges of the new Safe Harbor agreement. And I would ask you that if one were brought 6 months from today, would the court look at the equivalence of protections in Europe versus protections in the US? And would it look at it under the current security and surveillance practices of European governments and US governments? In other words, it won't look back to 2000, or it won't even look back to 2015, but contemporarily in a post-Paris world, that equivalence question could come out very differently in a subsequent challenge to Safe Harbor 2.0, given the surveillance practices of European governments today?
I'm not sure there's a question there, Steve, but first of all, the most dangerous thing that any commission official or any governmental official, for that matter, can do is try to predict what the court will or will not say. And I will certainly not do that with our top court. So if a
Well,
case
I was
will
asking
come
if they're allowed to look at the contemporary
Yes.
situation as opposed to historical.
that very much depends. Okay, now I get the question. Sorry, Steve. I really did not see a question there. Now I get what the question is. As far as I know, yes. But that very much depends on the kind of questions that are asked to the court. In the particular procedure that, again, sorry to be technical, but I think it's important to keep in mind that in the court procedure that ultimately led to the annulment of the Safe Harbor decision, the European Court of Justice was asked certain questions. In this particular procedure, which is a request for a preliminary ruling, if you're interested, it's a way in which the European Court of Justice is asked by a national high court of one of our 28 member states how it should interpret, how the national high court should interpret European Union law. And that was the question that in the Schrems case was asked to the court. If the European Court of Justice asks different questions, it will probably give different answers. And again, I don't want to speak with the court, and quite frankly, I cannot speak for the court. But I don't see why the court could not assess the specific security situation on the basis of the information that is provided by the government. And there again, allow me to make another point, that in the particular procedure that was followed in the Schrems case, again, a request for a preliminary ruling, the European Court of Justice, it's not that it had the choice, was not allowed to seek facts. It had to rely on the facts that were provided to the court by the referring court, which in this case was the Irish High Court. There are other procedures in our system in which the European Court of Justice can actually seek facts. So again, a court decides on the basis of the docket, so to speak, on what is being presented to it, and it's the responsibility of the parties, which are either parties to the case or are not parties, but entities which have an interest in the outcome of the case, to present the proper information. And personally, I believe that in the Schrems case, not all the parties that now claim they have an incredible high stake in the Safe Harbor, I don't think that all those parties took the time to present all the information that they should have presented to the Irish court, so that that information would reach the European Court of Justice. I hope I'm not being too Byzantine, but there are limits to what I can say as a Commission official, so I hope that's enough.
Okay. One thing that I think, I'll pivot a little bit. One thing that's emerged from some of the morning remarks as well is this difference between small companies and large companies. And Mr. Schrems' remarks also touched on something interesting, that there were a large number of companies under the Safe Harbor that really aren't subject to FISA at all. Is there any way forward maybe to make a distinction between, we're always talking about Google and Facebook, but there are also certainly a lot of small companies who are just moving marketing data or something very simple. Any sort of suggestions or help for that segment of the industry?
In Max's remarks, there was sort of like, I guess, a bit of confusion, I think, from my perspective about whether a company in the United States that certifies under the Safe Harbor is subject to jurisdiction under FISA. It isn't, either or. I mean, if you're a company in the United States and you transfer data from abroad, and you're subject of and some of that information is subject to the interest of the intelligence community, you're, as a U.S. company, subject to the jurisdiction of FISA. There isn't like you aren't a FISA company. If you're on the PRISM slides that were leaked by Snowden, you're subject to certain requirements, and if you're not on those slides, you're subject to different requirements. I don't think that distinction really exists. And so if there's a carve-out perhaps in practice, it turns out that retail companies don't tend to be subject to FISA requests. They should be subject to sort of different Safe Harbor requirements than other companies. I don't think that in practice that's going to end up being something that's feasible to sort of make that sort of distinction.
My colleague is much more, is better prepared to talk about companies and what their interests are, but allow me to point out one thing, and I know this might be unpopular, and we are very conscious of the economic impact of the Schrems decision, of the importance of Safe Harbor. And I myself work in the private sector for many years before joining the Commission, so all of this is not new to me. And we want to make sure that companies, both quite frankly, especially European companies, but also American companies on a fair level can operate properly. But let us not forget that, again, the main reason why the court struck down the 2000 Safe Harbor decision were 3 articles in the Charter of Fundamental Rights of the European Union that has very little to do with whether life will become more or less difficult for companies with the new Safe Harbor framework. You might be happy or unhappy about that, but that's the legal reality in which we are living. So I want to be extremely clear. We have been very careful throughout the negotiation to make sure that whatever we come up with will not unduly penalize small companies or even large companies for that matter. I think large companies can handle post-Schrems world without too many problems. They have the money and the lawyers to do that. Small companies have a more difficult life. So we've been very careful. We're trying to be very careful. But ultimately, when, and I personally think it's a when, it's not an if, when we will find ourselves again in front of the European Court of Justice to justify, to argue for the new Safe Harbor framework, whatever it will be called, the court will not ask, so has this been good, or will not only ask, has this been good for business? It will ask, is this compatible with Article 7, 8, 46, and whatever else of the Charter? And this is something we need to be very much aware of.
I think there's a question.
Alan Rawls, Sidley Austin. First, a clarification and then a question. I think that there is one distinction under FISA that may be relevant, which is under the 702 program, PRISM, that was the subject of particular concern to Mr. Schrems in Ireland. That applies to electronic communications providers, so companies that are not in that business it wouldn't be relevant to them. They might be subject, but it wouldn't be relevant. With regard to Article 7 and 8 for privacy and data protection that Mr. Glorioso just mentioned, would you imagine that in future legal rulings, or would the Commission take into account the obligation to balance the interests of privacy and data protection, which, while fundamental rights are not absolute, of course, and required to be balanced with other important interests, including security of individuals, including the right to conduct a business, and so on, and also balanced with respect to the international trade obligations of the European Union to grant most favored nation and national treatment status to the United States, which appears perhaps to not be receiving the benefit of the same margin of discretion that Europe grants its own member states with regard to surveillance, and other countries with respect to which the EU has found adequacy, that whose legal regimes also have surveillance and national security exemptions. Thank you.
Thank you, Alan. That's a most interesting question. I don't think I will be able to answer it in this panel. We'll have a beer or something and we'll go over it. And we're speaking hypothetically, I imagine. So hypothetically speaking, the obligation to balance, as you point out, both in the Charter and in general under EU law, there is always a balancing test to be made. Article 7 and 8 on the protection of privacy and personal data have to be balanced against other fundamental rights that are present in the Charter. Now, of course, the Commission is a largish entity. It's not as large as some think when they try to cut our budget, but it's still a largish entity. And if you talk to people who have been within the Commission working on privacy for 10 years of their life, they will have a certain perspective on what is more or less important. If you talk to people who have been working on support to small and medium enterprises, they will have a different perspective. That's a natural part of life, which is why all our legislative proposals and also the non-legislative proposals always go through what here in the US would be called an interagency process, so that different voices can be heard, and then people get together in a room, we throw chairs at each other, and then at the end we come up with something that hopefully makes sense in a balancing way. From my perspective, the most interesting part of your question concerns the international trade obligations that you mentioned and the most favored nation principle. There will, and here we're really going to rather complex stuff, and I'm speaking completely hypothetically, but under international trade law, under the WTO regime, as you know better than me, and specifically under GATS, the General Agreement on Trading Services, there is a general exemption in that agreement for all parties to that agreement for privacy matters, just as there is for national security matters. So in general, I think that I obviously, as a Commission official, I would not say that we have violated in any way or form neither the letter nor the spirit of international trade law in the way in which we implement our privacy regulations towards third countries. On top of that, as you know, we, since privacy and personal data protection are for us fundamental rights. I'm not saying they're not for the US, I'm simply describing how they are seen in the EU law and policy context. We don't do trade deals on them. And it's very clear in TTIP, for example, as you all know, in the Transatlantic Trade and Investment Partnership, the EU-US trade agreement that we are working on, our mandate, the European Commission mandate, the European Commission negotiates on behalf of the European Union in trade negotiation, and our mandate specifically excludes privacy matters from TTIP. And you can find very similar carve-outs from the mandates of other trade discussions. Because since privacy and personal data protection are fundamental rights, we don't believe that you can actually have economic deals, commercial deals out of that. What that means in terms of the most favored nation principles and others, for that I think I will have first to do my homework and restudy what I studied about international trade law, and then we will need to have a bit more time to discuss that. And I hope that kind of answers your point, which I think is a very interesting one, by the way.
Okay, looks like we have just about 5 minutes. Make sure we have time for any other questions, thoughts, comments?
Meg's back with us if she has anything she'd like to say as well.
Meg, any comments or thoughts?
No, I just thinking about what Andrea just said. Andrea always talks too fast for me, but I think that when we talk about balance, this is much more important in European law and balance and priorities. But I think what balance actually looks like in this area is a set of balanced decisions where in those decisions you had to make a bunch of hard choices. And right now it feels like the hard choices are that companies can have data, and they can't. U.S. companies can't have data unless the U.S. government is going to stay out of it. And these big questions about the balkanization and the future of the internet, those I think are the series of choices that we make to avoid this balkanization of the internet. But the really hard questions I think today is not that we need to make a balanced decision, that this needs to look balanced today, but that over the next 5 to 10 years that this needs to look like a balanced regime between our two regions.
Thank you. Thanks, Meg. Any predictions? I feel like I should sell those squares with the dates. Safe Harbor 2.0, Bijan, what's your guess?
I'm not in any office pools on this.
You don't have to participate. No.
We're optimistic based on sort of the things that Justin has said and the things that Ted has sort of largely laid out for us, similar to what the Secretary of Commerce said last week out of Davos. Something is going to come down the pike, perhaps a political agreement within the next week and a half or so by the February 2nd deadline, we hope, of the Article 29 Working Party meeting. More into the weeds on the agreement, one of the things that we think is positive, and I think sort of responds to what Meg was saying about this balance constantly being shifting as time goes on, is the sort of the process of revisiting adequacy decisions by the Commission over the and the safe harbor over a number of years. I think that's something that is largely both sides are comfortable with. I think companies would prefer to have one agreement hashed out that'll last for the next 20 years, but we understand, I think, that things on the ground change a lot, and the fact that this is a process is something that we can understand.
Okay. Any last questions or concluding remarks from the panel? Anybody? Okay. Thank you to our panelists for this interesting discussion. I promised him that I would be responsible for some housekeeping at the end of the session. So the schedule is changing a little bit. The 3:50 p.m. Dynamic Trends panel has been moved to 2:40 in room 709 across the hall. And in this room, also at 2:40 will be the International Perspectives panel featuring Assistant Secretary Strickling. And then the fireside chat, which your program says is at 2:40, is at 3:40 in room 806, which is across the hall, just across the hall. Okay.
And
all right.
There's coffee now?
And now there's coffee. Thank you very much.
Thank you very much.